Living wills and power of attorney for healthcare. What do they cover? Watch this video to understand key medical issues to address in your living will and power of attorney for healthcare. Keep in mind you have several options and a lot of flexibility when creating your living will and your durable power of attorney for healthcare. But you've got to be aware of some problems, and here is how to make sure you identify and fix them before you can no longer speak or act for yourself. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I hope you are doing fantastic. If you are doing as terrific as I am, go grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about living wills and powers of attorney for healthcare. What do they cover? Let's first talk about your living will. Your living will, also called healthcare declaration, is where you write out what you do and do not want in terms of medical care if you are unable to speak for yourself, God forbid. You don't need to become a medical expert to complete your documents, but it will help you become familiar with the kinds of medical procedures that are commonly administered to patients who are seriously ill. Let's talk about a few of them here. We're going to talk about life-prolonging medical care, food and water, and palliative care, pain relief. First, life-prolonging medical care. In most states in the Union, living wills ask you whether or not you want to receive life-prolonging treatments at the end of life. Such procedures typically include transfusions of blood and blood products, CPR, cardiopulmonary resuscitation, diagnostic tests, dialysis, administration of drugs, use of a respirator, and surgery. The great thing here is that if you want more information, you can reach out to your doctor or a patient representative at a hospital or health insurance plan office. You can even turn to self-help resources for more detailed information. Remember that when it comes to living will, you have templates out there. So it's not something you have to craft yourself from scratch. No. Healthcare declaration, aka living wills, every state has their own template and it's pretty uniform across the board. So that's for a life-prolonging medical care. Let's talk now about food and water, which is another thing you will need to include in your living will. If you are close to death from a serious illness or are permanently comatose, you may not be able to survive without the administration of food and water, unless you indicate that treatment should be withheld. Doctors will use IV, intravenous feeding or tubes to provide you with a mix of nutrients and fluids. IV feeding, where fluids are introduced through a vein in an arm or a leg, is a short-term procedure. Tube feeding, however, can be carried on indefinitely. If you have permanently unconscious patients, they sometimes can live for years with artificial feeding and hydration without regaining consciousness ever. If food and water are removed, death will occur in a relatively short time due to dehydration rather than starvation. Such a course of action generally includes a plan of medication to keep the patients comfortable. So when you make your healthcare documents, you got to be very sure about what options you want. You can choose whether you want artificially administered food and water withheld or provided. This decision is kind of difficult for so many people, and for good reasons, right? You have here a constellation of factors: emotional, physical, metabolic, psychological, and it's not just from the patient himself or herself. We're talking here about the family members also. Think about if, for instance, a daughter learns that her father is okay, has stated in his living will that he not be hydrated or fed artificially, whereas the daughter would have wanted her father to, quote unquote, stick around for longer, even if that means that he's in a vegetative state. He will never regain consciousness. The daughter will still want to see her father. So you want to keep in mind that as long as you are able to communicate your wishes, by whatever means, you will not be denied food and water if you want it. Let's talk about palliative care pain relief. So if you want death to occur naturally without life-prolonging intervention, that is, it doesn't mean you must forego treatment to alleviate pain or keep you comfortable. This type of care, sometimes known as comfort care. So when you hear the term palliative care versus comfort care, they mean the same thing. Rather than focusing on a cure or prolonging life, palliative care emphasizes quality of life and dignity by helping a patient remain comfortable and free from pain until life ends naturally. Palliative care may be administered at home, in a hospice facility, or at a hospital. You may wish to spend some time educating yourself about palliative care. You can include your feelings and preferences and priorities about such care in your living will. Let's also talk now about DNR orders and post forms. DNR means do not resuscitate. So some people who don't wish to receive life-prolonging treatment when close to death, most likely those who are already critically ill, may want to prepare a do not resuscitate order. If a medical emergency occurs, this form alerts emergency personnel that you don't wish to receive CPR, cardiopulmonary resuscitation. If you are in the hospital, your doctor can add a DNR order to your medical record. If you are not hospitalized, you can make what's called a pre-hospital DNR order. Let me repeat that. You can make a pre-hospital DNR order to alert paramedics who come to your home or care facility. Besides preparing a pre-hospital DNR order, you can also try to obtain an easily identifiable medic alert type bracelet, anklet, or necklace. So we have a vast majority of states right now, about 30, 35, where DNR orders are being included in or replaced by a broader set of medical orders called physician's orders for life-sustaining treatment, POSTs, or something similar. So in addition to instructions about CPR, POST forms include directions to healthcare providers about other life-prolonging treatments. I'm talking here about antibiotic use, intubation, or feeding tubes. In this matter, a post form is something like an advanced healthcare directive or living will, but it is not a complete substitute for those documents. We've had a long conversation around post form in another show. You might want to double check that show and learn more about it. If you think you might want to make a DNR order or post, you want to talk to your doctor or hospital representative ASAP. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie QE. We are having a conversation today around living will and powers of attorney for healthcare, what they cover. If you love the clarity and quality of the show so far, please consider subscribing to our channel and turn on the notification bell so you can be notified, that is, whenever we drop a new show. And we drop this kind of shows every single day, rain or shine. Let's talk about your durable power of attorney for healthcare. You can use a durable power of attorney for healthcare to name someone, in this case your surrogate, your healthcare agent, to oversee your healthcare wishes and make any medical decisions that are necessary for you. You can give your healthcare agent as much as or as little power as you feel comfortable granting. Most people give their healthcare agent comprehensive power to supervise their care. The power of attorney form that you have in your state will give you more information about this, but most powers of attorneys across the country give your agent the authority to make all healthcare decisions for you unless you specifically place limits on that authority in the document. That means that your agent will normally be permitted to consent or refuse consent to any medical treatment that affects your physical or mental health. There are usually exceptions to this rule for situations such as extreme psychiatric treatments or termination of pregnancy, and your agent is not permitted to authorize any acts that violates the wishes you've stated in your living will. So courts are really great at ensuring, I would say, a healthy balance between the responsibility of the agents in caring for you, and your instructions that you put in the will in the first place. Your agent will be normally permitted to hire or fire medical personnel, make decisions about the best medical facilities for you, visit you in the hospital or other facility even when other visiting is restricted. He or she will be able to gain access to medical records and other personal information, and get court authorization if required to obtain or withhold medical treatment if for any reason a hospital or doctor does not honor your living will or the authority of your healthcare agent. Let's talk a little bit about organ donation and body disposition. This is something you can also include, you can talk about, you can indicate in the durable power of attorney for healthcare. Most of your agent's authority under a durable power of attorney for healthcare will end upon your death. In the majority of states, nonetheless, you can give your agent permission to oversee the disposition of your body, including authorizing an autopsy or carrying out your wishes for organ donation. If you want your agent to have these powers, though, you should say so in your power of attorney document. You have to specify. If you have particular wishes about those matters, your living will is a great place to write them down, and you want to do so ASAP. Your agent is legally required to follow your instructions whenever possible. This is what the legal expert called fiduciary responsibility. In other words, your agent has to work in your best interest, even if you're no longer a part of this world. Besides organ donation and body disposition, there is also another element you want to pay attention to, and that is limiting your healthcare agent's authority. As I said earlier, it really depends on how much power you want to grant that agent. If you happen to not trust the agent 100% on everything, on some things relating to your healthcare, then you can limit that agent's authority. Keep in mind that as long as you are able to understand and communicate your own wishes, your agent cannot override what you want. He or she steps in only if you can no longer manage your things on your own. Besides, as I mentioned earlier, you are permitted to restrict your agent's authority in any way you like. For example, some people might give their healthcare agent only the authority to carry out the healthcare wishes specified in their living will, and not to make other medical decisions for them. You want to think carefully and thoroughly, however, before you add limiting language to your power of attorney. One of the most important reasons for appointing a healthcare agent is so that someone will be there to respond to the needs of your situation as it develops. Your medical needs may change in ways that you cannot foresee at the moment, and an agent who has full power can act for you no matter what the circumstances are. Let's talk a little bit about choosing your healthcare agent. If you need, there are several ways you can pick a healthcare agent. This person does not need to be a lawyer, does not need to be a doctor, it does not need to be a parent, a relative. It's up to you. It's all about how you feel. It's all about the trustworthiness. It's all about what you want the agents to do, your relationship to the agent, the trust you have developed with that agent over the years. This is what's going to help you choose your healthcare agent. Some people choose doctors, some people choose best friends, some people choose their spouse, their adult children, their adult child. It's all a matter of personal decision. All right, folks, this is pretty much it. Just want to recap today's conversation. So I was talking to you about living wills and powers of attorney for healthcare. What do they cover? And today I spoke to you about your living will, life prolonging medical care, food and water, palliative care, pain relief, DNR orders, and post forms. I also spoke about your durable power of attorney for healthcare. So having a conversation around organ donation and body disposition, limiting your healthcare agent's authority, and choosing your healthcare agent. Thank you so much for listening to this conversation. I really appreciate that. I will see you next time. But until then, remember, stay marvelous.